We review the evidence that law enforcement submits to us, and we determine whether or not it is legally sufficient and just to proceed. I want to switch gears a little bit and say, I'm sure many of you have heard about the very tragic murder of a young woman in 2007 named Brittany McGlone. For more than a decade, that case was handled not by the Wood County District Attorney's Office, but by the state prosecutor, the Texas Attorney General, after my predecessor recused himself. Over those many years, despite extensive investigation and the involvement of very experienced prosecutors and investigators, that case was never presented to a grand jury because the evidence was deemed insufficient. In 2016, a very senior prosecutor with the Attorney General's office wrote to the victim's father and warned that rushing forward without sufficient evidence could result in a very swift not guilty verdict. And once that happens, double jeopardy, which is a legal term, forever bars another prosecution. So once that person is found not guilty, they can never be tried again for that offense. Even if new evidence later emerged, it could not be prosecuted again. And to me, that would be a tragedy, and that would be a failure of the justice system. Years later, without any new evidence, only simplistic reinterpretations of the old evidence, the Wood County Sheriff's Office sought and obtained a capital murder arrest warrant without consulting with my office. In a death penalty case, consultation with the DA's office is not only customary, it is critical, and that did not occur. And I'll tell you why that's critical, because police, they're not lawyers. And on my desk, I have all kinds of law books. And so they are not, which is not a problem, they are not skilled and trained in reading laws and seeing what is needed. Because the police officer's burden to arrest somebody and to build the evidence is probable cause, which is the very lowest burden there is in the criminal system. My burden as a prosecutor is to prove the case beyond a reasonable doubt, which is even the highest burden in Texas, which is even higher than the burden that CPS has to remove children from homes. So think about that. That's my burden once I get into the courtroom. The case was delivered to my office 34 days after a suspect was arrested, and that left only 56 days to review thousands of pages of documents before a deadline was to seek an indictment. So in Texas, you have 90 days once someone's arrested to seek an indictment and to have one returned. If you don't get that done in 90 days, then that suspect can get out on a personal recognizance bond. And I'll tell you, that does happen. If a case does not get to us in time, then the person gets out of jail. That delay significantly reduced the time that was available for careful and thorough review. And let me tell you why that's important. We get taken about 700 cases a year, and there are only 6 prosecutors, including myself, and I do carry a caseload. A lot of district attorneys do not. They just do the administration, but I still carry a caseload. And so that, with all the other cases we had, I had to put all those aside and focus solely on that case for 56 days. And because of the volume of that case, I enlisted one of my assistant prosecutors, a young man named Logan Sawyer, who is 31 years old, a graduate of Tech, and very astute at technology. So Logan and I split the documents up, we split the case up, and we worked from start time to finish time every day on that case for about 56 days. While speaking with the Attorney General's office, which was part of us reviewing the case, I learned that they had to provide a copy of the file on Brittany's murder to the Wood County Sheriff's Department on multiple occasions. And that was because of the changes in administration due to the election of new sheriffs. There is no way to verify whether any administration of the sheriff's office has maintained a complete and original file of the case. And you may ask, well, why does that matter? I'll tell you why. Because death is different. So capital murder, you can seek the death penalty from a jury. And we say death is different because you have to have all of the evidence in order, not missing anything, not forgetting something. Everything has to be turned over to the defense attorney. And in this particular case, that defense attorney was very skilled, and he came to me and said, "What is this?" And he is a man that only tries capital murders. So while speaking with them, and I found out they had to have that file, we don't know if they have the original file or not. But I can tell you that asking for that file from the Attorney General's office every time leads me to believe that they probably do not have the original file. Additionally, documentation from the Attorney General's office reflected that materials previously provided to the Sheriff's office were requested again and that items could not be located. Even more disturbing, evidentiary items that were relied upon for the development of the theory of the case by the Sheriff's office submitted to us was based upon evidence that could not be located. The integrity and the preservation of evidence is foundational in any prosecution. So think about that. If we don't know where the evidence is, a defense attorney is going to hold that up in court and say, what else have they lost? What else are they hiding? And that will be held against us. There were also significant investigative gaps. There is no new physical evidence linking the accused to the crime. There's no DNA evidence that was developed after the suspect regarding the accused suspect. No forensic testing produced conclusive results that tied him to the offense. I've heard that there's claims that he confessed to one of my assistants. That's not supported by any written or recorded statements submitted as evidence. In fact, the accused has denied involvement in multiple interviews. Certain items that were relied upon in the probable cause affidavit, such as underwear compared to a Kohl's sizing chart, were not forensically tied to the victim through DNA or definitive proof that they were even worn by her. There is documentation indicating that the items may not have belonged to the victim at all. Moreover, when the case reached our office, some of those same items reportedly could not be located in storage. Further, no consultation occurred with my office during the renewed investigative efforts prior to the arrest warrant being sought. That's important because prosecutors can assist with those search warrants and can assist with those evidentiary standards necessary for trial. That collaboration did not happen here. And I'll tell you, it does happen with most law enforcement agencies. It's not unusual for me to have officers coming in and out, asking me for my opinions. Despite these challenges, my team and I worked tirelessly. We then presented the case to a grand jury, and a grand jury is made up of 12 citizens from throughout the county that are selected by the district judge. They're not selected by me. It's the district judge's grand jury. After hearing all of the evidence, that group of 12 people declined to indict at that time. They determined that there was not even probable cause, remember that low burden, to proceed to an indictment. And probable cause, again, is way lower standard than beyond a reasonable doubt. I've also heard that I told the grand jury how to vote. That's not true. That's false. Grand jury is autonomous. When they are deliberating, we are not allowed in the room with them. Only grand jurors are allowed in the room to discuss the case. Prosecutors just present the cases that law enforcement turned over to us. Prosecutors do not investigate. It is outside of my duties to go and investigate a case. That is what law enforcement does. And the reason we don't do that is if I'm out here investigating and finding evidence, that can make me a witness, and then I'm not going to be able to prosecute it. There's legal rules regarding that. Law enforcement investigates, prosecutors present. No one from my office was present during grand jury deliberations. Their decision was their own. And since that time, many accusations have circulated, especially on social media and elsewhere. And this is where I want to stop and ask you. The Bible says that whatsoever things are lovely, pure, true, noble, that we should think on those things. And I will caution you about reading everything that you believe, that you see on Facebook. Most of it, I'll tell you regarding this, is absolutely false. And you may ask, well, why have I stayed silent so long? As a prosecutor, my role again is to seek justice, and in doing that is to protect the integrity of the case. If I go out there and I talk about all the facts, and it could possibly damage the case. And so that's why grand jurors have a duty to stay secret and silent, and then prosecutors have a duty to protect the integrity of the case. Let me say plainly, the defendant is not related to anybody in my office. There is no admissible confession, and if there is, law enforcement has not turned it over to my office. There is no admissible polygraph. Polygraph results are not admissible in court in Texas. There is no newly developed forensic evidence sufficient to meet the burden required for this indictment. I spoke with a lady named Kelly Siegler who hosted the show Cold Justice. I didn't know who she was when she called me. She called me and she said she wanted to talk to me about this case. And I had the other attorney that was working on the case with me in there. And Kelly, Miss Siegler, I learned, I didn't know her before this, is a career prosecutor herself. I talked to her, I answered her questions. I also mentioned that the Attorney General's office had had the case for a decade and had not sought an indictment. And the Attorney General that had handled the case, all she did was go around trying murders and capital murders for DA's offices. So she was very experienced, Lisa Tanner. And I told Ms. Siegler what Lisa Tanner had advised me about the case. And when Ms. Siegler was informed of Lisa Tanner's opinion on the case, these were her words: "I am sorry to have wasted your time." She chose not to proceed on the case. I never in any way tried to thwart that show. I never denied Ms. Siegler access to the case, nor did I tell her that I would not cooperate with the case. I told her exactly what she wanted to know. She made the decision based upon what Ms. Tanner, who is well known in our circle of prosecution, what her thoughts were on the case. As prosecutors, we do not investigate. We prosecute the cases that are brought to us. We cannot manufacture evidence, we can't overlook case weaknesses, and we cannot ethically proceed to trial unless we believe that we can prove a case beyond a reasonable doubt. Sorry, my mouth. And I wanted to tell you this. If we take the wrong case to trial and lose, we can never try that person again. Even if new evidence later proves guilt, that's the weight of their responsibility. The winds have blown, the rains have fallen. There has been criticism, complaints, attacks on me and my children. But my integrity will not be shaken. My duty is not to secure headlines. It's not to secure favor from people in the community. My duty is to stand upon the rock and to seek justice faithfully and lawfully. From the beginning, my heart has been for Brittany McGlone, and for people to say otherwise is very hurtful. I have spent my life prosecuting people that have done horrible things to victims. And I was reminded this week about a case, a child sexual assault case. And we presented the evidence, and we knew that it was going to be a tough one. And the jury found him not guilty. And I will never be able to shake that young girl. She was a teenager. The look on her face when she knew that he had gotten away with it and there was nothing I could do. From the beginning, my heart has been with Brittany McGlone. I have teenagers right there. The family, they deserve justice that will stand up in court. They deserve a case that is complete, carefully investigated, and supported by reliable and admissible evidence. They deserve a prosecution that will not collapse under cross-examination. So today, I ask for your prayers for Brittany's family, for law enforcement, for my office, and I'll take it a step further. I ask for prayers for my children because they didn't ask to be in this position. And I would ask also that you pray that we in the justice system will pursue truth with humility, courage, and unwavering integrity. We will continue to seek justice in this case. And it is my hope that one day that we can take that case to a trial and to continue prosecuting it once the evidence is a firm foundation. So I want to thank Pastor Greg and Miss Sherry for having me today and my children. And I want to thank you, and I want to remind you that Paul says to pray for those in authority.